Hi everyone, this is John Girardi with Right to Life of Central California, bringing you another in our 40 Videos for 40 Days series. 40 Days for Life is an international campaign of prayer and presence outside abortion clinics throughout the country and throughout the world. If you want to participate in our 40 Days for Life campaign here in Fresno, I encourage you to get in touch with us. Give us a call at 559-229-2229 or visit our website, rtlcc.org. Sign up, come out, maybe dedicate a set hour for yourself once a week and join us in prayer, maybe every Tuesday from 11 to 12 or however you want to set it up. We'd love to have you out there joining us. Again, rtlcc.org. Today on the show, I want to talk about a disastrous a case that could have been a really disastrous Supreme Court case. How come the Supreme Court never issued a kind of Roe v. Wade for physician-assisted suicide? Assisted suicide is another one of the big issues we deal with here at Right to Life of Central California as another attack on innocent life, legalized physician-assisted suicide. The reason there was never a Supreme Court case that was sort of the Roe v. Wade of physician-assisted suicide, a case where the Supreme Court declared out of thin air that there was a constitutional right to physician-assisted suicide, was because of the greatness of William Rehnquist, the former Chief Justice of the Supreme Court. It was a case called Washington v. Glucksberg. In Washington v. Glucksberg, basically a bunch of liberals were alleging, a bunch of more liberally minded people who are in favor of physician-assisted suicide, were arguing that, much like abortion, much like the arguments for abortion, that the 14th Amendment of the Constitution contained an unenumerated right to physician-assisted suicide. The 14th Amendment says that no person shall be deprived of life, liberty, or property without due process of law. Now, while this sounds like a procedural guarantee for fair trials before you execute someone, take their life, throw them in jail, take their liberty, or fine them, take their property, a lot of more left-leaning justices on the Supreme Court interpreted this more broadly and basically said, well, certain kinds of rights have to exist in American society in order for there to be due process, things like privacy. And from the right to privacy emanated a right to abortion, and that's how we got to legalized abortion for all 9 months of pregnancy for any reason. So liberals in the early 90s were trying to argue the same thing for assisted suicide, basically saying, hey, there's certain rights that have to exist in order for due process to be there. There's a right to privacy. There should be a right to kill yourself and to have a doctor help you, and for that doctor not to be prosecuted with a crime. Well, the court didn't really buy this, and what Justice Rehnquist did in the Glucksberg decision is basically try to put a limiting principle on this idea that you can just cook up whatever rights you want out of the 14th Amendment. And basically what he said was, look, we cannot create new rights wholesale out of the 14th Amendment unless they are essential to a system of ordered liberty and are rooted in the history and tradition, the legal history and tradition of this country. And what but he developed this standard, and in doing so, Rehnquist said, look, there's no way possibly to argue that a right to have a physician help you kill yourself is either essential to any scheme of ordered liberty, nor is it at all something that's consistent with the history and legal tradition of this country. And as a result, the Supreme Court said, nope, we are not declaring some universal constitutional right to physician-assisted suicide. So the Constitution doesn't really say anything about it. So if you want to pass physician-assisted suicide in your state legislature, by all means, but we are not going to mandate it on the rest of the country. This was, I think, a very wise decision by Justice Rehnquist, and I think it was pretty profound that he was able to get a majority on a court that's that was much more liberal then than it is today, and kind of testifies to the greatness of the man that he was so shrewdly able to lead the court towards developing this really great doctrine. Justice Kavanaugh, who clerked. He didn't clerk for Rehnquist, he clerked for Justice Kennedy, but obviously he was a clerk that is a young attorney who is assisting a Supreme Court justice in legal research and writing and drafting opinions and such. He was obviously a clerk for the court while Rehnquist was the chief, and clearly has a ton of respect for the Chief Justice, and even gave a speech in 2017 before he was nominated to the Supreme Court talking about the Glucksberg decision and how important and correct and essential it was, even acknowledging that by the Glucksberg standard, probably we would have never gotten Roe v. Wade and Planned Parenthood versus Casey. It's Kavanaugh's admiration for the Glucksberg decision that I think gives me the most hope that this year, when the court hears the big challenge to Roe v. Wade, Dobbs v. Jackson Women's Health Organization, that Justice Kavanaugh will be that decisive fifth vote to rule the right way. Yeah, I'm already kind of waving the white flag on Roberts doing the right thing. I think he's sort of stabbed us in the back too many times for me to trust him. Anyway, for Right to Life of Central California, I am John Girardi. Thank you so much. And again, I hope you'll sign up for 40 Days for Life. Please get in touch with us. Take an hour spot, rtlcc.org. Thank you.